background on this one. Mr. Schuster is representing himself. The court has previously gone through the waiver of right to counsel. When we were here, I believe the last hearing, Mr. Schuster gave an indication that he wanted to resolve these matters. So I have drafted a plea form with the city's offer on it. I just am not sure how to get it to him. I can certainly send it to him in the chat. I just don't know if he has the ability to download that and sign it if in that respect. So,
hi, ma'am. How are you today?
Hold on a second. So let's preliminary matter. This is Jonathan Schuster, 4A0525748. So it sounds like Ms. McDonald's trying to get you some documents, Mr. Schuster.
Yeah, so for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary. I had mailed out some paperwork over to the prosecution as well as submitted it to the courts. Were you able, have you received those, ma'am?
So I've received 2 motions from Mr. Schuster. Have you?
Yeah, the 2 motions as well as the affidavits, as well as the certified copy of the. So you got that paperwork? Were you able to read it?
I have 2 motions. One was, both were received today.
Right. You should have received an affidavit as well.
I don't see any affidavits.
The affidavit was received at the same time that the motions were submitted, and so.
And I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I
emailed to Ms. McDonald this morning.
You did? I'm sorry, what, Madam Clerk?
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster. Hold on, Mr.
And
Schuster.
so, as well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
I just wanted to make sure I said that. Thank you.
Madam Clerk, did you send that to my email or did you send it to the office email? Because I don't have anything from you today, except the orders from Mr. Bailey Garrison and the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine. I just require that due process is, that we.
Okay, hold on, Mr. Schuster. There's gonna be plenty of time for you to talk.
Yes. Thank you. Also, the prosecution, I've never received anything from you as well. But there is an email on for contact information, so you can send that over via email if you have anything to send to me.
We sent you discovery at both addresses that you gave to the court, so they were physical copies because there's digital.
I've never received anything from you.
Well, it went out to your mail, so I don't know what to tell you about that.
Did you check, Mr. Schuster?
I mean, I haven't received anything.
That's not my question. My question is, are you checking your mail regularly?
Oh, I definitely look out for mail regularly.
Okay, and does the court have your current address?
So he updated it, Your Honor. We actually had this situation issue a couple of weeks ago, or actually almost a month ago, where we had sent out full discovery to the defendant, and then he indicated that that wasn't his address. So we sent out another packet of full discovery to him to the address that he updated. Let's see, the one on Kenyon Street.
2318 California Avenue.
You gave us on January 27, 600 Southwest Kenyon Street, apartment G201 in Seattle.
You're talking about on January 27th when the judge denied subject matter jurisdiction that day?
So the address that you gave to the court on January 27th was the 600 Southwest Kenyon Street, apartment G201.
Is that the address you gave on January 27th?
I don't recall, but I do have, somewhere she can send it to. So
well, we're not going to play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it, and I don't recall. So I'm giving you an address, but
you recognize that address?
Which address?
Can you read that one more time, Ms. McDonald?
Yes, the address on January 27th that he requested discovery go out to was 600 Southwest Kenyon Street, apartment G201 in Seattle. The one prior to that he requested was 1005 North Cleveland Street, apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the judge denied your motion to dismiss for lack of subject matter jurisdiction.
That wasn't till later. But regardless, you did receive the 2 motions as well as the affidavit today. Is that correct, ma'am?
I did. Did Ms. McDonald? Have you gotten that yet?
I just
Perfect. Have you had a chance to read over that, Miss?
So obviously Ms. McDonald has not had a chance to read over it.
Oh, I was referring to you, ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
From the beginning.
That's not my question, Mr. Schuster.
Well, I'm answering your question. I would like.
Before we jump into today's courtroom showdown, buckle up because this case takes a turn almost immediately. The defendant is representing himself and appears determined to challenge the court's authority from the very first minute. But here's the catch. When you choose self-representation, the court expects you to follow the same rules as a licensed attorney. What happens when someone insists the court lacks jurisdiction while the judge keeps trying to move the case forward? And could a simple plea deal have avoided all of this? Watch closely because this hearing becomes a masterclass in how procedural arguments can collide headfirst with courtroom reality.
I don't want a narrative. Yes or no?
Thank
Do you
you.
remember signing this piece of paper?
I don't recall.
Okay.
I don't know what paper you're showing me.
You're on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just
Schuster-
very hard to read because it's blurry
Okay.
from this
So
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
This isn't the trial.
Nonetheless, I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I reviewed these motions. There's 2 of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion, finding that this court, again, does have subject matter jurisdiction, and this case will proceed. So those motions are denied. I am also not really interested in hearing that you have yet a third new address for Ms. McDonald to send discovery to. So at this point,
It was never a third. In the beginning, you had the correct.
At this point, we're already seeing a pattern develop. The court and prosecutor are focused on practical issues, service of discovery, mailing addresses, and trial preparation, while Mr. Schuster continues steering the conversation back toward jurisdiction and procedural objections. This is one of the most common dynamics in self-represented cases. The court isn't deciding guilt or innocence today. It's trying to determine whether everyone has the information needed to move forward. What do you think? If you believed the court lacked authority over your case, would you continue raising that issue at every opportunity, or would you focus on preparing a defense for trial while preserving your objections for appeal?
Address, it's no longer the correct address.
then it's
And
not
so-
the correct address. If it's no longer correct, then it's not correct. You've given a
Well, as of
address.
recent, as of literally not that long ago.
So when
so-
when did the Kenyon Street address become a bad address?
I want to say within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
It's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated.
I can
And
tell
this
the
is a
court.
court of record, correct?
Is a court of record.
You said this is a court of record?
It certainly is a court of record.
Ah, I see.
We are on the record now. So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that, everybody has the correct information.
What is your current correct address?
The mailing address would be 2318 California Avenue. I believe that's Southwest. D?
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family. And so, just so I'm clear, you're saying that the right to travel and privacy is not a federal matter, and that
I'm
you're
saying
saying
that-
that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington. And that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty, and a right, because no person shall be deprived of life, liberty, or property. You're saying that isn't a federal matter?
And there it is, the ruling. The judge has now clearly explained why the motions are being denied. Notice that the court isn't debating whether constitutional rights exist. Instead, it's addressing a much narrower legal question, whether this municipal court has authority to hear the charges filed in this case. The judge's answer is an emphatic yes. This is where many jurisdiction arguments run into trouble. Simply invoking constitutional principles isn't enough. Courts generally require a specific legal basis showing why they lack authority over the matter. The bigger question now is whether Mr. Schuster will adjust his strategy or continue pressing the same arguments despite the ruling.
I don't want a narrative.
I'm
Yes or
saying
no.
that there are
Signing this piece
multiple
of
layers
paper.
of jurisdiction
I
that
don't recall.
involve travel.
Okay.
I don't know what
that
paper
the
you're showing
fact that
me.
there
On
are
this piece of
federal
paper.
rights around travel
I'm not
does
sure
not
what paper you're
preclude Lake
showing me,
Forest Park Municipal
because
Court
it's
from
very
enforcing
far from the
state and
camera,
local ordinances.
and it's
Mr.
just
Schuster?
very hard to read because it's blurry
Okay,
So
from
what
this
do you
angle.
want
Let
to
me
do
read
on
it
your
to you.
case
So I
today,
don't
Mr.
recall.
Schuster? Is it your intention to go to
December
trial
16th,
next week?
2024,
Is it your intention
colloquy with
to
Judge Grant?
entertain a plea
During that
offer from Ms.
colloquy,
McDonald?
you engaged in a series of questions about your familiarity
Well, I
with the rules of
just
criminal
want the court to
procedure,
know that
criminal
any
courts in
judgment issued
general,
without
the
proper
Constitution, and
subject
so
matter
on.
jurisdiction
At the
is
end of
void
that,
and may
you
be challenged at
indicated
any
that you
time.
have
And
read
you're
and
free to
completed the
Court
form
ruling
and
from
lacks the
requested
authority
the
to
court
hear
to
this
allow
case,
you to
and
represent
proceeding
yourself,
further would
and you
result in
signed
an
it and dated
unenforceable
it and
judgment.
noted you reserve all
Therefore,
rights.
this
On that
must be
form,
dismissed.
you are
free
free
to
to
appeal
appeal
any ruling this court makes.
asked to do and
can certainly
acknowledge and
suspend-
Almost
understand
definitely.
is that you
how
will
to
be
do that.
treated as though you are an attorney,
Nonetheless,
and you will
we
be
have to figure out
expected
what
to
you're
follow
doing
the court
today
rules
on your
as though you
case.
were an
It's your
attorney.
readiness hearing.
One of those rules
Will you
that
tell
you're
us if
expected
you want to go to
follow
trial next week
is
or if you want to
the
entertain a plea
Lake
offer
Forest Park
from Ms.
Municipal
McDonald.
Court local rules around how to
Well,
file and
as
proper
I've
notice
stated,
of filing
this
motions.
case should be moved
The
to the proper
local
courtroom,
court rule
which
that's
it's
requires
not.
that if it's a
And
motion
so
that is
And
not
that's
set
not
on the
happening
day
in
of
Ms.
trial, that the
if it's not
expectation will be
transferred,
that you give
I
21
do
days
think
notice
it should be
and
dismissed.
properly serve
And
the
if
other
it's-
party.
Entertaining further motions
These
to dismiss.
motions dropped
Ms.
off,
McDonald, go ahead.
emailed, whatever to the
And
court the
Mr.
day
Schuster,
of
I
and the day
sent to you
before the
in the
hearing
chat
are not
because
properly
that is
noted
the only
under
way
the
for me
local
to
court
get that to you
rules.
right now.
Oh, no, you have my
Nonetheless,
email.
nonetheless,
You got the
I am going to let you know
the information
that I
on
have
the
reviewed these motions.
motions there.
And if it's
So
okay
you
with you,
have-
Ms.
you have the
McDonald,
email
I'm
listed
going to go
above.
ahead and
I
let
don't
Mr.
really know how to
Schuster
use
know
Zoom
that I reviewed
like
these
that.
motions.
And
There's
so
two of them, a
sending
motion to
anything
dismiss
over
for lack of
through
subject
chat
matter
like this is
jurisdiction,
just
and another
it's
motion that is
difficult.
essentially a show cause
So
motion
email would be the
for
best way if
prosecutor
you want to
to
get that to me faster.
appear and show cause as to
But of
why
course, you have
there
an
is
address
subject
now
matter
that
jurisdiction in this
I'd be able
case.
to get
And what I
the
want to
mail,
tell you on the record right now is that Lake
saying
Forest Park
you've
Municipal
sent
Court
already,
is
but no
authorized to hear
worries.
misdemeanor and gross misdemeanor cases
I'm
along
using
with
Zoom the
violations
same
of
way we
local
used it at the
ordinances.
last hearing
We
when
are
we sent
not
you
authorized to
documents
hear
and you were
federal
able to
matters.
chat back and
Your
forth with me.
assertion that we are not
So it's
authorized
in
to
that
hear
We didn't
federal
have
matters
a
is
we didn't have
absolutely
a
correct.
back and forth
Nonetheless,
chat.
these are not
No,
federal
we didn't.
matters.
So there is a document
Federal
in
courts do
the
not
chat
have exclusive
for you
jurisdiction
to
over
open and take a
travel and
look at,
driving
and that is the
offenses.
city's plea
Proceeding with
offer.
this
We are
case is not
agreeing
a
to
due process
dismiss two
violation
charges
of
for
the
a plea to
Washington
one
or the
with a
federal
credit for time
Constitution,
served
and so I'm
recommendation.
going to deny your motion to
So
dismiss
it's
for lack of
as
subject
stated,
matter jurisdiction.
you can
Turning to your
email
motion
it
for
so
show
that I can
cause,
properly
you
see it. 'Cause
cite an
that's the best way
RCW
for
that
me to do
outlines
it
district court
quickly.
jurisdiction, which is not even
because
applicable in this
I
case,
don't
but
really know
nonetheless,
how to use this
Lake Forest
chat
Park Municipal
function
Court is
in
the
Zoom.
correct venue for misdemeanor and gross
Ms.
misdemeanor
McDonald, you have the
driving
ability to
offenses
email it
that
to him.
occur in Lake Forest
You're
Park,
looking for the
Washington.
email?
The constitutional right to travel is
Yep,
not
it's at the
abridged
top
by
for the
states and
motion to show
municipalities'
cause, as
adoption of
well as
regulations
the-
concerning.
The conversation has now shifted into territory that viewers see in countless courtroom disputes. Mr. Schuster is connecting the right to travel with the court's authority to enforce driving-related laws, while the judge is drawing a distinction between constitutional freedoms and the state's ability to regulate conduct on public roads. Whether viewers agree or disagree, the judge is attempting to separate broad constitutional concepts from the specific charges before the court. Here's something worth discussing in the comments. Do you think people sometimes confuse constitutional rights with immunity from regulations, or do courts occasionally interpret those rights too narrowly? Let us know where you stand.
Bottom of the motion for dismissal. But I can also just read it to you if you'd like that.
If you can put that into the chat so I can make sure that I don't spell it wrong, that would be great.
Well, as I've told you, I don't know how to use the chat.
So we're streaming live to YouTube, Mr. Schuster. Would you like to read your email for anyone who's watching YouTube to listen to and hear?
I mean, They can email me. I don't mind.
Then
Yeah.
spell out your email for Ms. McDonald.
Do you know how to spell my last name, Miss McDonald?
Please just spell it out. Let's just be as clear as possible.
Well, it'd be my last name .jon at iCloud.com.
Can you spell your last name for her?
Yeah. Are you ready, Miss McDonald?
Yes, I am.
Okay. SCH.
What?
Can you hear me?
Yes, I can.
Oh, okay. I wasn't sure if you could hear me. I know we've had trouble communicating over Zoom because sometimes you can't hear. And, it's actually pretty ironic that you say that about the email, but then mailing addresses are said out loud too. So that's just kind of ironic
So far,
that you would mention that.
yeah. Well,
But
as I said at the beginning,
it's
court, everything's being broadcast on YouTube. But
Oh, I know.
now we
But
need to
nonetheless,
respond to the fact that you have changed your address repeatedly.
n-
So, Ms.
nonetheless,
McDonald
that's
is
just
emailing you.
ironic.
Ms. McDonald is emailing you a copy of a plea offer.
Cool. You said you were going to send that in the mail as well, or
No,
information in the mail.
it's not coming in the mail. It's coming via email right now. You have the opportunity to
I'm
review
talking
it
about
right now.
like the other information she was.
No, that's already been sent in the mail. You need to go to wherever those addresses were to get your discovery.
Mm.
The discovery was sent out on February 10th, approximately a week and a half after you gave that address on the record.
On the record, when the judge denied subject matter jurisdiction?
When you were in court on the record.
On that day, when she said she denied subject matter jurisdiction. Yes, I remember her denying subject matter jurisdiction.
You also gave an address. Ms. McDonald sent your discovery to that address about a week later.
So you're saying that you can't send that to the proper address, Ms. McDonald?
We've already sent it to both addresses that you provided to the court.
What she's saying is you can't come to court once a month, change the address, have her send out discovery, and then come back a month later and say that wasn't the right address to send it to.
So you're not going to send it to the proper address. Okay.
Did that get sent, Ms. McDonald?
Yes, it did.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right.
So my email, I'm using the same.
Camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get back on it.
Okay. One moment.
Can you mute yourself, Mr. Schuster, and turn your camera off to read your email?
Oh, I saw that Carmen had sent something over.
Yes, you need to open it and review it.
Oh, it says what you had said on the record, correct?
No, it's an entire form. It's about, see how many pages that is? About 8 pages.
Can you mute yourself and take yourself off video while you review that, Mr. Schuster?
I think so. Let me see if I can do this correctly. Oh, so I see everything that you sent over. Obviously, I'd probably have to look at it longer to make sure I
asking you
carefully.
I'm asking you to do that now. We're going to go back on the record.
Oh, okay. It just might take some time. I've gotten through some of it, but for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time for all of that, but if you do, I don't mind. Taking the time to fully get into it.
Ms. McDonald, you're on mute.
If he's asking for more time to go over the city's offer and to consider that, I don't have an objection to continuing the matter if he agrees to waive speedy trial.
Oh no.
Well, if you don't wish to waive speedy trial, then
Well, if she doesn't want to give me more time, then I guess we just got to.
Well,
You
the problem is, Mr. Schuster, you have to be brought to trial within 90 days of your arraignment date. And so your trial is scheduled for next week, but if you want to take advantage of the city's
On
offer,
the 11th,
right, if you want to take advantage of
9 a.m.
if you want to take advantage of the city's offer and you want more time to review it, unfortunately, you would need to set over that trial date.
Well, I can counter to you right now if you'd like.
I'm happy to go in a breakout room.
I don't know what that means.
I don't know that these are necessarily conversations to have on the record, but
if you want to go into a breakout room, in other words, go into a separate Zoom room with just Ms. McDonald so you can discuss her offer, I'm happy to allow you to do that right now.
Okay, how does that work? How do we do that on Zoom?
I can do that. I can put you in a breakout room. You'll get an invitation.
Do I
Something
need it? Okay.
pop up on your screen for you to accept.
Okay, so just wait until something pops up.
Yep, I'm going to put you in there right now. It will be into room 1.
How would I come back though?
There will be a button on the bottom right that says leave breakout room and back to main session.
Okay, so it says join breakout room. Prosecutor McDonald is inviting you to join room 1. So I just click join.
Yes, and I'll be in
Okay.
there.
All right. To have a conversation and track what's going on. I offered her a counter, and she didn't want to take it, and so that's where we are, ma'am.
So
Podcast on YouTube, but
Oh, I know,
now we
but
need to
nonetheless,
respond to the fact that you have changed your address repeatedly.
nonetheless,
Ms. McDonald
that's
is
just
emailing you.
ironic.
Ms. McDonald is emailing you a copy of a plea offer.
Cool. You said you were going to send that in the mail as well,
No,
information in the mail.
it's not coming in the mail. It's coming via email right now. You have the opportunity to
I'm
review
talking
it
about
right now.
like the other information she was.
no, that's already been approximately a week and a half after you gave that address on the record.
On the record, when the judge denied subject matter jurisdiction
When you were in court on the record.
on that day, when she said she denied subject matter jurisdiction. Yes, I remember her denying subject matter jurisdiction.
You also gave an address. Ms. McDonald sent your discovery to that address about a week later.
So you're saying that you can't send that to the proper address, Ms. McDonald?
We've already sent it to both addresses that you've provided to the court.
What she's saying is you can't come to court once a month, change the address, have her send out discovery, and then come back a month later and say that wasn't the right address to send it to.
As we wrap up this courtroom encounter, several key themes stand out. The judge repeatedly affirmed that the court has subject matter jurisdiction, denied the motions challenging that authority, and kept the focus on moving the case toward either a plea resolution or trial. Mr. Schuster, meanwhile, remained steadfast in arguing that the court lacked the authority to proceed. Whether you view his persistence as principled or counterproductive, there's no denying that he stayed committed to his position throughout the hearing. Ultimately, this case highlights a critical reality of the legal system. Courts operate according to procedural rules, and those rules continue to apply even when a litigant fundamentally disagrees with the court's authority. If you found this courtroom showdown fascinating, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and legal analysis.